Bene, buonasera.
Good evening. So we are a little bit shy to start this dialogue, and I'm referring to the previous meeting, which has been very, very dense and very intense. However, we will do our best to spend the time we've been devoted. Mr. Giovanni Legnini has been engaged in policy for several years. He's been serving the police for several years, and over the last 4 years, he's been the president of the High Council of the Judiciary. So his task is similar to that of the president, but the president of this council is the president of the republic. And so he has the functions of the president of the republic in this very, very important institution, and has been dealing profoundly with justice-related issues. And he came to the meeting, one of the previous meetings, to talk about these topics. And he was here with Judge Mr. Giovanni Canzi. So the title that we decided to give to this meeting, the injustices of justice. So I would like to start from this point: what is just and what is not just, whether what is just and fair coincides with what is not just, whether it is possible to have a correct relationship between the power and justice. These are all topics that have been dealt with and that have been debated for several decades, and we've had echoes just a few minutes ago. The relationship between the evil, what is fair, what is just. It is a problem which has been tormenting mankind since mankind has started to ask questions about the destiny, the fate, and the human existence. And this topic has returned over the last few months, because Luciano Violante and Marta Cartabia have just published a book titled Giustizia Mito. They describe the figures, the mythical figures of related to justice, Antigone, Oedipus, and so this topic has become very topical. We've also heard a lot about Job and the universal nature. I would like to know from Giovanni Legnini whether, on the basis of your work and your service to our country, to the police, over the last few years, you think that we will ever be able to provide an answer to the question, what is justice really about? When we talk about justice, we always put justice in relation with something else. Justice is always considered as something which is in relation to something else, in relation to the evil, to the mistakes, to the crimes, and to the real context of our everyday lives. I would like to welcome you again here. Welcome back to the meeting. And I hope that although your task as the vice president of the High Council for the Judiciary is about to end, well, this is not going to be a reason to not come again to the meeting. So our dialogue will certainly continue in the future. But I would like to focus on the key topic of today's debate. How can we define justice? What can we say about justice? Is it something that we as humans can really understand? Is it in our hands to understand what justice is? Thank you very much to the meeting organizers for inviting me once again, for giving me the chance to be here. But I said it to you earlier. I would like to thank you for leading me to this dialogue, and I also had a chance to say this to other friends I've met. The Rimini meeting has always been a place of extraordinary debate, dialogue, comparison of ideas, cultures within the movement and between the movement and the other participants of dialogue, whatever their origin. But in this historic moment, this place, this appointment, this meeting is one of the very few opportunities in which it is possible to develop a dialogue and a comparison of ideas. And this gives the meeting a further value and a further strength for the well-being and for the general interest of all the Italians. Secondly, I am accustomed to take on the challenges. I'm used to face very demanding situations, difficult situations. I've experienced many of them over the years. I cannot give you details on many of them because of confidentiality, of course. But, facing the challenge of a dialogue after listening to Julian Carron in the previous session with such dense contents and with such intensity. The previous session was very rich in details. Well, this is really a challenge. So I would like to thank you all for being here and for your patience. As for your question, as you said in the preliminary remarks, well, it is in some relation with the remarks we've been listening to during the previous session. So the question of raised by Job, why? That why is an expression of the question you were mentioning earlier. What is just and what is not just? What is fair, what is not fair? It is a dramatic kind of question for any of us, for the entire human community as a whole. And it has, today it has new aspects, because between the ethical dimension, the moral dimension, and the dimension of the set of laws, there has been some sort of asymmetry, a misalignment. Although in the presence of a constant tension towards a set of rules that is capable to adopt and receive in the legal rule the moral law and the ethical dimension. We have been recently experiencing a crisis in this relationship, which is still necessary. The crisis, which has become deeper and harsher over the last few years, what is considered just or right by all of us or by a part of society is not always confirmed as just in the set of laws, in the set of rules. What the set of rules considers to be just, so what is an imperative rule, is not always perceived as just by the community or by a part of the community or by some citizens. So there's some sort of conflict between the two dimensions. However, I repeat it, the need for a relationship, the need for the moral rule, which adds on, which integrates, and which goes beyond the legal rule, the juridical rule, is a need for all the states, and it is a need for each and every one of us. The Confederation of Italian Bishops in 1961, in a document on legal issues, underlined this difficulty. And I will quote, the respect for the laws is not simply a formal action, but a personal gesture which finds in the moral order its soul and its justification. So this is a pillar, it's a fundamental pillar, and this explains how the fall of the sense of the legal, of the sense of law, has repercussions on the sense of solidarity between men and their morality. So the fall of the sense of the law then had a precise root: the crisis of the sense of solidarity, a crisis in the way to manage the power. So that was a reflection, a debate, which involved experts in legal aspects, lawyers, magistrates, and it is still topical today in our days, in which this contradiction seems to be even deeper. But we need to realign the sense of justice, which is fundamental for men, and it has to be aligned with the adequacy of the set of laws. And where is the crisis I was mentioning earlier? The crisis lies in the fact that the national states, the lawmakers, and we will talk about this later on, in some way, the judges, the magistracy, not always manage to interpret the sense of justice, which is constantly evolving, and it is also constantly evolving due to the changes in our era, as Pope Francis mentioned. And this change refers to several aspects. And I will conclude by saying that we need to rethink about a regulatory system to contents of our own set of laws. We need to think about the law as a whole, as a system which is capable to meet the requirements related to justice, facing old and new injustices. So this is a sense of the first answer that I was given a task to give you. So if I interpret it well, properly, we have two dimensions. A dimension which has always accompanied the life, the thought, and the reflection, namely justice. What is it? What is justice? And this is something which is permanent in the conscience, awareness, and the soul of man through generations. And then on this, you can have the changing context, the changes in the cultures, in the changes of problems, of needs, of requirements. And on this dimension, we can find this deep crisis. Yes, it's correct. This phenomenon you're describing leads to another point of crisis. When I talk about crisis, I refer to the better meaning of this word, crisis, which means a break, able to generate new hopes. The fact that confronted with an ancient function of rules, of the laws, reading the phenomena of life, predicting facts, not only the facts which have already occurred, but also the facts which may occur. Otherwise, the law, a law which can be enforced only for the future, wouldn't have any sense. So this ancient habit, which led to define over the centuries the sense of state, the primacy of law, well, today we are experiencing a crisis. And we're experiencing the crisis because the facts of life and the changes we are witnessing are becoming more rapid than the ability of the lawmakers to fix the rule for the specific fact which is occurring. I could give you lots of examples. Up until several centuries ago, would someone have been able to predict the migration flows we are experiencing now, or the pervasive nature of the digital and technologies in our lives? Could anybody have been predicting the effects of such a devastating economic crisis, not only for Italy but for the entire Western world, and the social economic effects on the lives of people, as the effects we've been registering over the last 10 years? And when it comes to the power of the state, has the lawmaker been able to provide an effective rule to intercept those phenomena that have been becoming more and more visible with such a strength? This is the question that has to be analyzed by the lawmakers and by the governments. And this question is all the more significant and relevant, and it is so relevant that it is necessary to rethink about the way of issuing rules. And those phenomena which have marked the change in our era need to be considered as phenomena which occur on a global scale, on a supranational level. And the state dimension has become too shrinked, too limited to be able to intercept phenomena which occur and which go beyond the national boundaries. And since the imperative rule cannot but regulate the facts which occur within the boundaries of the state where this rule is enforced, this crisis entails other questions. It is not a chance that among the experts of law, the so-called multi-level sources are being explored. Not only the source, the legal source coming from the state, but also the European sources of law. The European law is quite pervasive in many aspects of the lives of the European citizens. And then the sources related to the facts, and then the sources coming from the international law, which are becoming more and more important because of the need. We all need a global vision, and we need to focus on our global power, which is able to regulate such phenomena. We could give lots of examples in this respect, even examples strictly referring to the topical issues. I was mentioning the phenomenon of migration flows, but we could also mention some facts which were dealt with by many magistrates in many countries. For instance, the tax rules when it comes to the giants of the web economy. So this great ability they have to avoid taxation in many countries. Or another example is related to the safeguard of personal data and the safeguard of privacy, faced with an enormous ability to store data on the part of the social media, and not only them. So these phenomena and globalization, the globalization of this phenomena, weaken the states and weaken the strength of law. This is another of the factors for the crisis, but it is one of the factors which should push us towards a greater integration, a greater European integration. And I'm convinced about that. It should push us towards a further dialogue and the identification of tools to govern these elements at world level. So over the last few years in the political debate at European level, but not only at European level, I'm thinking about the global phenomenon of the dimension, the reduction of the weight of the classical state order. This has led to opposite phenomena, the attempt to recover the sovereignty of state and to set aside or to move away from the weight of globalization, or move away from the weight of phenomena at global level, and I'm referring to several economic phenomena. So this is a reaction. You're describing a reaction, and we should not neglect or underestimate the strength of this kind of reaction. This reaction is attention to sovereignty, to national sovereignty, or the reaffirmation of the reasons of the nation states, national states, or the safeguard of identity of the nations, whatever you want to call it. In any case, it is evident that such a reaction occurs if the answers provided in the past by the law and by the set of laws at national level are not provided by other subjects. If you think about it, the crisis at European level may also be attributed to what you were mentioning earlier. This is one of the most dramatic topics of our days, and they deeply affect the decisions of the public opinion. It is a phenomenon which also affects the key question: what is just, and what is just, what is correct, what is right, what is not right. A scale of values, a moral order, a consequent system of rules, which in the past were fixed at national scale, and these are no longer able to give answers and to provide responses in a quick way. And this leads to fears, to uncertainties, to lack of orientation and fears, and all those elements lead in turn to stances which tend to reaffirm the reasons of the boundaries, the importance of identity. We were used up to not so long ago to these elements before the great changes occurred. But well, I would like to dwell on maybe on a trivial question which is present in our everyday life. Will it be sufficient? Will it be enough to simply get back to the national states and to the boundaries in order to solve the problems and to give an answer and to provide a response to the new injustices? So we should try and think about the contents of two very important encyclical letters of two living popes, Caritas in Veritate and Laudato Si. As for Laudato Si, which, as we all know, tackles the enormous topic of the environmental sustainability, well, it has a chapter, a whole chapter devoted to justice, putting, relating the exploitation and limited nature of natural resources with the inequality and the new demand for justice, and therefore with the need to define rules and a legal framework, a juridical framework which is able to govern phenomena which occur partly on the territories but also on a global scale. Let's think about the a topic of pollution or climate change. As for Caritas in Veritate, that you mentioned, well, that's a real economic global program. This is the way I interpreted it when I read it. It is very, very rich in contents, and, well, it raises thousands of questions on globalization, first of all, and on the need to realign through charity, through to actions for free, the moral rules and the scale of values we all need, also with an economic and juridical order. That is also an exhaustible source of food for thought, and it is able to give us a key to read what is currently happening, and it also provides some hints for being able to grasp some opportunities on the part of mankind. There's a book
dall'anno scorso di un pensatore studioso anglo-indiano che si chiama Pankaj Mishra, che si intitola L'età della rabbia. Ha avuto un enorme successo, un bestseller internazionale, perché anche solo il titolo, poi il libro è documentato, è un'analisi molto importante, piena di lavoro serio, voglio dire, ma anche solo il titolo ha trovato il modo, come dire, di come una didascalia che in un attimo, in un istante fa capire.
The title was very catchy, of this Age of Rage, and so this book has become sort of very popular. And so it's about these new and recent phenomena that we have gone through, and so it covers at least 20 years, and it's very interesting. It covers also the main features of the events that have characterized the last years, and in particular it focuses on the need for justice. And there are events, there are situations that sort of trigger this sort of need to find a culprit, to find somebody to blame. And there are also references to the earthquake in L'Aquila in Italy, and there are references also to the attempt to involve experts in the debate, experts that had not perceived the danger, or maybe, the blame is put on surgeons or doctors or physicians that do not sort of succeed in healing patients. So again, and also the recent tragedy of Genoa is another example. So, people sometimes need, when faced with extreme events, to find somebody to blame, to find somebody who's guilty, to find the guilty ones. So the need and the quest for justice justify the need to find sort of a person in charge for that, to find the guilty one. Well, your question raises another chapter of reflections, because, rage and sort of discomfort, new forms of injustice and distress and social distress, marginalization. So all these events trigger new sort of forms of behavior. And we had the crisis. It was very deep in Europe and in Italy in particular. But also, there are other root causes. For instance, we should consider what happened in emerging countries, or at least the countries that we define as such. Countries that today grow extremely quickly, and there are other new problems, the redistribution of resources, of wealth, of employment. So all that generates resentment, generates rage, and so that's what triggers this need to find a guilty or the guilty. That entails one major consequence, and in particular, it would be very dangerous to underestimate this consequence, because if sovereign states are not able and capable to provide an answer to these questions stemming from social discomfort, and if the international community hasn't defined yet rules or decision-making processes likely to provide answer, well then, and if we think about our daily experiences, we can ask ourselves, so then, if all that is missing, citizens, what should they do? I mean, in your opinion, if there are no rules, no organized legal frameworks, if there are no answers provided by those in charge, so if the citizen cannot rely on a sort of protective establishment, if the establishment does not provide any answers to the questions triggered by rage and raised by citizens, what can citizens do? Well, then citizens will react in a new way, and so ask for justice. And for instance, they submit legal proceedings to a court, or they just have recourse to the judiciary system. You mentioned the earthquake in L'Aquila, something that sort of hit me. I followed it in my capacity in professional terms, but also as a person who was born in the Abruzzo region. And I must say that not long ago, I was talking with Franco Roberti, who has been in charge of the mafia fighting and tourism fighting entity. And he had been touched in his life by the Irpinia earthquake. And I asked him how many criminal inquiries, how many restorative procedures were launched and triggered. So how was the situation for the judiciary? And he said, well, very, very few of all that. Or if we think about the repercussions of some natural disasters, or if we think about some responsibilities when it comes to sort of violating rights. So that I think about the big provider of public services, and let's think about both public and private operators and companies, and again another reference to the tragedy of Genoa. So what's the growing trend? So that's exactly what I was talking about. There's a leading tendency. So if citizens do not get answers from laws, from rules, from the government, if there are not enough resources, if even the European sort of entities do not respond, so what can a citizen do? So citizens decide to have recourse to judges and to sort of use legal proceedings, and we have today the non-liquid principle. I mean, any judge if consulted, has the duty to provide an answer. So it's a professional duty. It's something it can't dodge. I mean, this is imperative for a judge, if consulted, to provide an answer. So in the past, some of these answers used to come from the legislative power and from the executive power, but over time all that has changed, and there has been a shift towards the judiciary system. So shall we call this like a sort of replacing function, or maybe a judiciarization of social relationships, or a new way to fix conflicts and disputes? I don't know, you name it. But certainly this marks another step in our sort of epochal change. And so in the past, the idea, for instance, to have recourse to legal proceedings against the national railway company, or to an energy provider, or to a flying company, or that because of a heavy snowfall and no cleaning of the roads, people could have recourse to legal proceedings against the municipality. All that was unthinkable in the past, but this response to this need to claim one's own rights, and not just basic fundamental rights, but any rights. So over the last few years, for instance, we have committed ourselves strongly to better understand and decode, and then also guide and inform and raise awareness vis-a-vis several interlocutors over time. The jurisdiction and have become heavier and heavier, but I mean, it was not something that was done on purpose. Well, was that done because it's greedy? No. Well, there has been sometimes maybe some sort of specific isolated cases, but I want to underscore one thing, in particular in relation to a phenomenon that was groundbreaking and that started in the 60s. I'm referring to the riots of 68 and the 68 movement. And there is here at the meeting a wonderful exhibition on that. And then a part of the judiciary decided to take up this task of disrupting judiciary conformism and propose interpretation rules of legal norms that were more creative. So I may go on for hours on that, but still there, in that case, there was a specific cultural imprinting, especially when it comes to judiciary culture. Well, regardless of agreeing on or not, but for instance, there were almost non-existing environmental protection rules. And for instance, also the right to work was something very poor. And we had, for instance, lower court judges and magistrates that started to play a very important and new role. So they were called sort of magistrates taking things by the storm. But today we're in a different situation, because if laws cannot sort of fix disputes. If governments are not able to provide answers, well, then citizens ask for answers directly and precisely and in a targeted way. And so it's not the citizens' fault to ask for that. It's not the citizens' fault because they want an answer, they did not find it, and so they ask for it. So it's a brand new aspect that certainly has marked a major epochal change. So really, it's about the judiciary power extending its role and function and also changing its role and function, being forced to provide answers that are not always tackled by other parliamentary rules. For instance, I could talk about ethical issues. Many of them have been first tackled by courts, by judges, and then, and not always, by lawmakers. Well, I think that what you're saying is extremely interesting because it really sort of raises a pivotal issue when it comes to constitutional law and power and daily rules. This is something that has to do with our daily routines, our daily lives, and our way to relate to the others. So, if I got you well, you said that these separation between justice order, law order, moral order, and this somehow is the conduct outlined in the bishops' sort of committee. So, but that may have brought about an imbalance because the manager, the financial operator, have become like neutral agents. So these people are seen as neutral from a moral and ethical point of view. The same applies to politicians and then to journalists. So then it will be up to judges and magistrates to judge the good grounds or not of those deeds perpetrated by those people, because there seems to be no ethical order, no ethical provisions, because everybody relies then on judges and courts and magistrates. So I'm maybe simplifying a bit too much. So I do what I want because, well, then somebody will tell me if I did something wrong or not. So this is certainly one side of the issue. This is also one of the consequences and one of the dynamics I tried to trace. But there is another element to be considered that is very close to what you have just illustrated, and that is a consequence of what I've tried to present you with. There are some law experts that say that actually we have gone far beyond, and maybe we've gone too far when it comes to the traditional separation of powers. And, well, we could further elaborate on that. But personally, I have a different take because I must say that some people think that the separation of powers has changed. Fortunately, it existed and it still exists. So this is a very important principle that is contained in our constitution. Well, even if sometimes the legislative power seems not so effective, is there consolidated, the executive power is consolidated, and the judiciary power should not go beyond the borders set by the Constitution. What I want to emphasize is not just the risk or the certainty, according to some people, of this fact of putting at stake the separation of powers, but as you said, this situation may lead to a conflict, or maybe it has already generated a conflict between politics and justice and politics and the judiciary. Well, because the questions raised and asked by citizens, so questions raised and triggered by injustice, both new and old, are not fulfilled, neither by the executive power nor by the legislative power. Instead, these people tend to have recourse to the judiciary. And sometimes there is unsuitability of the laws or a lack of laws or a sort of bad wording to push the judge to provide a free interpretation of that piece of legislation. And so that creates a sense of substitution. So what had to be decided by deputy members actually is decided by judges and by courts. So this seems to generate a sort of perennial conflictual situation, and that leads not simply to mistrust or lack of confidence vis-à-vis the judiciary system, and instead, oddly enough, some people have more and more expectations, not really more trust, but more expectations. But still, that feeds and promotes a certain mistrust and lack of confidence in the establishment, in the institutions. So again, we go back to lack of satisfaction, resentment, rage, and these are more and more common phenomena. And in my opinion, this is one of the major traits of the dynamics of the social system we have today. This characterizes also some dynamics that we can observe. I think that we all remember all the conflicts between politicians and magistrates. And I think that actually they are not that important in relation to this epochal change. I would like to go back to another thing. Let's make an example. A journalist publishing, for instance, documents or papers that from an ethical point of view should not be published and disseminated, and that sort of are confidential, but actually these papers are published because journalists justify themselves by saying it is my duty to make these news circulate, and then the sort of the ontological problems should not be posed any longer, because then there is going to be a court issuing a judgment on that specific case. But still, I think that this is one of the major consequences of this separation that you also mentioned. So the ethics that should be at the basis of anybody's behavior, especially of those that work in the media sector, the financial sector, the economical sector, and more generally in sort of technological sectors, should not turn an ethical problem into a legal problem, so that if a judge is going to issue a favorable ruling, that means that I was right. If it doesn't, maybe I was not that right. But still, this brings us back to the starting topic of this conference, because not any question. I mean, not all of the questions and not all of the issues can be solved and fixed by laws. There are issues that cannot be fixed or solved by laws. There are some structural problems. So no, not all behaviors can be, let's say, guided into specific pathways or rigorous rails. I mean, it is not like that. As far as this item is concerned, I must say that the ethical dimension is something that should be considered and should go hand in hand with the legal dimension. So when it comes to moral rules, and specifically the moral rules that should sort of go hand in hand with the rules set forth by the law. There is another aspect to be considered, that is the following, and maybe this could be one of the answers to the crisis situation I was referring beforehand, because there's a sort of a growing level of activity by public powers, and this has to do with the so-called soft law category. So optional rules, guidelines, and the High Council of the Judiciary, within its secondary law-making power, that it's still rather important. Well, we have decided to be the protagonists of some initiatives that are remarkable in this respect. For instance, we have made some videos on communication of judiciary decisions, especially when it comes to the organizational profiles of communication of judiciary activities. And this is a major piece of news. We also adopted guidelines to improve the organization of the judiciary to fight against gender-related violence. We have launched several initiatives against the murdering of women. I could go on for a rather long time. Even within this context, we tried to consider the willingness and the wishes of the lawmakers when it comes to the sort of management of mentally ill people in order to better cope with them. And I really could elaborate for long on this. We have the ethical sort of area, and you have rules and laws, and sometimes you have deeds that can and should coexist together with deontological rules and ethical rules that are set forth as compulsory for some professional categories. So the crisis forces us to retrace a picture. We cannot say that any law of the state can fix any problem. We cannot ask laws of the state to do so. It would be very hard. The same applies to the European Union as a judiciary source. We cannot sort of think about the judiciary as the only outlet today to fix disputes. So especially when it comes to inequalities and disparities. We cannot think about answers provided only by the judiciary, but still each judicial institution should be aware that it's part of a system that is somehow redefining itself and reorganizing itself. Let's talk about the fight against corruption and the role played by ANAC. Again, this is about prevention and not repression. So it is an independent autonomy that had a surveillance power. It has been entrusted with some specific powers, some soft law tools and devices likely to prevent corruption phenomena in order to better guide the activities of companies and of public administration. So again, this patchwork of elements is redefining itself, is reorganizing itself, but it's not easy at all. So it stems also from the crisis. So we need a vision, we need more awareness. So any of the involved players should be more aware. You cannot be a deputy the same way it was 30 years ago. I mean, things have changed at all levels. So we cannot think about a judge and a judge's work as it was 30 years ago. So a judge is not simply the person in charge to apply a law, not at all. Judges are becoming more and more creators, and through interpretation related activities and through the case law, they are becoming more and more structured and complicated. So all that requires dialogue and exchange between and among powers and knowledge holders in order to get out a catch-22 of fear and anxiety, because there's a growing request for justice.
So drawing to a close, I would like to ask you something, since you are approaching the end of your of the duration of your post as the Vice President of the High Council for the Judiciary. I would like to ask you, what did you witness that you thought was unjust and that you wanted to repair because of your personal push, and you were not able to do, and what, on the contrary, were you able to see as unjust and repair? So kind of take stock of your job. I don't know, but I know that there is something which is very important for you, the topic of the reform of the jail system. I know this is an important topic to you. Well, the High Council of the Judiciary is a very complex and delicate kind of organism. It is difficult to carry out and to adopt decisions and to classify the decisions and its activity in the two categories of what is just and what is not just. We've always tried to interpret as rigorously as possible, with a due rigor and according to our functions. And this year we're celebrating the 60th anniversary of the entry into force of the law constituting the High Council of the Judiciary. Will be celebrated on the same date in which our mandate will be over, and we will hold a plenary session on that date, in the exact date And the plenary session will be presided and chaired by the head of a state, and in his quality as president of the High Council of the Judiciary, and it will certainly provide us with the highest and most competent reading possible of our task. We've tried to carry out our functions as rigorously as possible, but always bearing in mind the framework I've mentioned during this dialogue, namely the carrying out of the functions when it comes to bureaucracy, based on conservation, would have been out of the history, an aged kind of task. We had to interpret and we had to carry out our task, bearing in mind the changes which are constant in our role as judges and in our relationship with the society, and of the judiciary in its relationship with the other powers of the state. We've opened it up to the dialogue with other institutions, and we also dialogue with the independent authorities. We've talked about the rights, the injustices. We've talked about the new demands on the part of the citizens, and the extent and how much of this scare is now in the hands of other organisms. I'm referring to the ANAC, to the Agency for Fighting Against Corruption, the authority in charge of the safeguarding the rights of the children, and the authority safeguarding privacy. And so the activities I was mentioning earlier, and the activities related to the culture of the organization of judiciary offices, which was not a priority of the institution. So these two aspects, along with the complete self-reform of the rule for the secondary functioning, well, these are two reasons for satisfaction which accompany this demanding task. This is a very, very difficult commitment on our part. We also had to face several criticism in the past. Well, we could expect it. We've managed to change most of the heads, most of the executives and the heads of the judiciary offices in Italy. When the government, presided over by Mr. Renzi, decided to lower the maximum age for the post for magistrates, that was an advanced an exit of heads and deputy heads of the judiciary offices. So we've carried out 1,000 appointments with a very low level of disputes, and we had to face fierce criticism at times. As for the objectives, as for the targets, I was not able to achieve. Well, I think we are just at the beginning of a pathway that should lead the Italian magistracy, the judiciary system in Italy, to think about the need to increase the level of responsibility and accountability facing the growth of the power given to the magistrates by the citizens. The power of the judiciary order has been increasing, and not because of a choice of the magistrates, but because of the phenomena I mentioned up to now. So if the power increases, the accountability also has to increase. The willingness to dialogue, the willingness to listen, without neglecting and without relinquishing the principles of absolute independence. So considering that you are not confronted with a dossier, with a file, you have before you a personal drama, a personal claim, a crime, and you need to identify the culprit, and you need to compensate the victim. So this is a cultural evolution which has just begun, I think. I would like to have done more on this respect, but the fact of having opened up paved the way for a future reflection is a very good step forward. And then I have another regret, namely that considering the effectiveness of the power and the control on the correct functioning of the offices, and I have to say that the willingness to identify what has to be identified has not always emerged properly. I think that the justice when it comes to disciplinary deeds, well, functions very well. Those who think that the discipline-related justice given to the High Council of Judiciary, well, they are wrong. It is a rigorous kind of justice. However, there's a whole set of behaviors which should be identified better. And this is a task, first of all, of the magistrates who head the offices and who work in the offices and who know the offices very well. We need, and the Italian citizens need, bear in mind this epochal change, what we all need, certainties linked to the timely decision, but also the certainty that you have a judge before you who is impartial, independent, and I have no doubt about that. I know that our system guarantees these two needs, but also competent, well prepared, willing to listen, and keen on dialogue, and with no suspicion whatsoever of not being impartial. So we strongly need these elements because trust in the judiciary power and the effectiveness of the judiciary system is one of the points from which our country may start to grow again. And with this spirit in mind, we've tried to work up to now. Thank you very much. Thank you for your vision. Thank you for the vision you brought us, for your point of view, which is so in-depth. And we need to continue thinking, and we need to continue to provide a contribution. Thank you for returning to this place, which is one of the very few places where it is possible to carry out a dialogue, a balanced kind of comparison of ideas. And thank you, because I am certain that our friendship and our dialogue will continue in time. I am totally sure about that. Thank you very much. Thank you for listening to us.